and Assalamualaikum. We are students from CRG660. We are going to present about directors and fraudulent, no room to escape. First of all, I would like to introduce our group members. Our group consists of 4 members. I am NOOR ATIQAH binti AHIR. First of all, I would like to explain about introduction. So, Section 213 of the Companies Act 2016 states it is the duty and responsibility of directors to exercise their power for a proper purpose in good faith at all times in the best interest of the companies. Having significant responsibility in a company, directors shall exercise reasonable care, skill and diligence with knowledge, skill and experience which may reasonably be expected of directors having the same responsibilities, and any additional knowledge, skill and experience which the director in fact has. So next I will explain about Case 1. Case 1, Securities Commission Malaysia versus SYAFIQAH and ATIQ, Bright Packaging Industry BHD, Proposed Intervenor. The Plaintiff Securities Commission Malaysia and defendants SYAFIQAH and ATIQ. The cases about the first and second defendants were the directors and shareholders of the third defendants. The third defendant was a substantial shareholder of Bright Packaging Industry BHD (BPI), making the first and second defendants the indirect shareholder of BPI. Even though the first and second defendants were not the directors of BPI, they were its authorized signatories. Next, I will explain about issues or offence committed. The issue SYAFIQAH and ATIQ had used 3 corporate exercises as device, scheme, and/or acts which operated as a fraud upon Bright Packaging Industries. Substantially, payments were channeled through various nominee companies before being eventually transferred into the bank accounts of the first and third defendants. And the nominees companies were controlled by the defendants and were used as a front where these nominees companies received monies from Bright Packaging Industries based on fictitious transactions. So next, Lyana will explain about Case 2.
Hi, I am Lyana Adrina binti ROZAILEY. So I will proceed about Case 2, which is Maria Abdul Nasir versus Muhammad Khalid Nordin and others. The plaintiff is an individual, whilst the first defendant is the Chief Minister of the Johor at the material time. Had officiated and launched a program known as Johor MAD, the program on 25th April 2015. The plaintiff had also entered into a tenancy agreement with the fourth defendant, Majlis Amanah Rakyat (MARA), through a tawaran penyewaan date 13 Jun 2016 and perjanjian penyewaan date 7 Ogos 2016. Fourth defendant via a letter surat tawaran pembiayaan perniagaan MARA date 28 September 2016 offered the plaintiff a buy al-ina financing facility, the facility in the amount of 150,000 ringgit for the purpose of the plaintiff participation in the program. The facility was accepted by the plaintiff. Under the program, the plaintiff Johor MAD grocery store was finally established on April 1st, 2017. However, she experienced losses due to several problems. As a result, the plaintiff sent a letter to Berpadanan Usahawan Johor Sendian Berhad, a shareholder of the third defendant, requesting that the Johor MAD grocery shop be surrendered. Next is issue or offence committed. The issue is whether the fourth defendant was negligent in ensuring the proper management of the program. According to the plaintiff, there is a Memorandum of Understanding, which is MOU, attached as A2 to the affidavit in reply affirmed by the plaintiff on October 1st, 2020. And in the memorandum, it states that the fourth defendant assumed the duty and obligation to carry out a possible review of potential risk to plaintiff business. It has been found the plaintiff argument cannot be defended due to the fact that the MOU made was between plaintiff and the third defendant and not by the fourth defendant and was only copied to the fourth defendant. Furthermore, there was no requirement in the MOU or any document whatsoever for a feasibility study to be conducted. Next, for analysis of the two articles will be explained by NURSARAH.
Hi, I am NURSARAH SYAFIQAH with ISHAK. Next, I will proceed to present about analysis of the articles, status of the offences. From these two cases, director fraud occurs where a director of a company uses investors' fund for personal gain. It may also be called director theft or misappropriation of fund. It's a criminal offense of a director of a company to misuse investor money for personal gain. The director frauds not only about the embezzlement but can be the other cases. We analyze that the case depends on the charge by either plaintiff, an individual, or a company or government organization. Analysis that we made based on the court held or decision after the trial began between plaintiff and defendant. Next, the link between these two cases is where a director has made a fraudulent misrepresentation intending for another person to rely upon it, and that person does rely upon it and suffers a loss as a result. The director will be personally liable. This is one of the advantages of bringing a claim for fraudulent misrepresentation, as it allows the claimant to elect whether to bring a claim against the company or its directors. In practice, it likely that the claim will be brought against whichever party has the most money. Then, in the upshot for case 1, in our considered view, BPI has failed to satisfy the requirement of 0.15R.6(2) of the ROC, and that we can conclude that their presence is not necessary and they have failed to show any direct legal interest in the subject matter of the main suit. On the contrary, in our opinion, it will be in the best interest of BPI as a public listed company to allow this court to examine at trial the conduct of the defendant and to make a determination of whether the SC has established its case against the defendant. As indicated earlier, if BPI for any reason are of the view that the defendant have not committed any contravention of CMSA, the defendant are fully entitled to produce anybody from BPI to testify on their behalf. There is not necessity for them to be made a co-defendant. As such, BPI application include 107 to intervene as a fourth defendant is dismissed with cost of RM7,500, subject to 4% allocator to be paid by BPI to the plaintiff. Next, we will proceed for the next presenter.
Next, I will continue further analysis. Then the upshot for the case 2, we found the plaintiff argument untenable in the view of the fact for the MOU, which was between the plaintiff and the third defendants, was prepared not by the fourth defendants, but the third defendants and merely copied to the fourth defendants. Furthermore, there was no requirement in the MOU or any document for a feasibility study to be conducted. Based on the foresaid reasons and the judicious consideration of all the evidence before this court and the submission of both parties, this application was allowed with cause. In the final analysis, the plaintiffs had applied for an benefit fee from the financing, but unfortunately had faced challenges in the car-running business and had eventually failed. So the issue is if at all that she had faced with the third defendants had no relevance to the facility that she had obtained from the fourth defendants. Lastly, based on the foresaid reasons and the judicious consideration of all the evidence before the JC 2020, JC 2020, this court and submission of both parties, this application was allowed with cause. So, in conclusion, directors must know their duties and the importance for the company to maintain a good reputation for a long-term sustainability. The law has moved toward holding directors personally liable for their deceitful actions. As a director, it is pertinent to be aware of one's responsibility and liabilities, particularly the ones that had been statutorily laid down under Section 213 of the Company Act 2060, which require a director to exercise reasonable care, exercise his power for the proper purpose, skills, and diligence, and act in a good faith in the best interest of the company. From these two cases, we can conclude that a director has made a fraudulent misrepresentation intending for another person to rely upon it, and that person does rely upon it and suffers a loss as a result. The director will be personally liable. It also imposes personal liability on management, controllers, and directors to be the subject to legal action unless he or she can prove the offence was committed without his or her consent of connivance and due diligence has been exercised to prevent the commission of the offence. Therefore, companies are strongly advised to ensure they have taken reasonable steps to prevent corruptions and deceitful transactions at the company. Thank you.